The next matter to come before us this morning is Palazzo versus Palazzo. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve that time, let me know, as I am keeping the clock this morning. We've read the briefs and are ready to proceed when you are.
Thank you, Your Honor. I would like to reserve 5 minutes for rebuttal, please. Thank you. May it please the Court, my name is Leslie Grasky. I'm here on behalf of Cynthia Palazzo, the wife in this matter. This is one of those unfortunate cases where the trial took place over about 7 months. So I guess it's not really surprising that some items of evidence may have slipped through the crack. However, there are some that are particularly large and meaningful, and we would ask that this Court grant redress. For example, the business which was funded by the parties during the marriage, called Frontline, had an officer loan which it owed to John Palazzo as of the date the court valued the business. That receivable to John Palazzo had a value in excess of $40,000. Now, both of the business appraisers considered this officer loan when they appraised the value of Frontline. It's entirely appropriate. And if that debt had been owed to First Merit or PNC or some other third party, just reducing it from the business would be appropriate. However, it is also an asset. And it's an asset that belongs to John Palazzo, and it's an asset that is a marital asset. It is $40,000 which Frontline will pay to John Palazzo and which should be divided with Cynthia Palazzo. We would ask that the court directly order the division of the $40,185 officer loan. There was also a business called JZM. Now, this company was solely in the name of the wife. However, in the year when the parties were separated, but not actively in the divorce, husband depleted this by taking member draws in excess of $38,000. There was evidence that about $6,000 and some dollars were placed into the joint checking account and were used for normal expenses. However, as to the rest, over $31,000, husband simply testified that he spent it. It's troublesome that the decree specifically says there was no evidence as to member draws from JZM, whereas in fact, there was considerable evidence as to the $38,000, and twice the judge asked Mr. Palazzo, please, I would like to know what you did with that money. And there was testimony that he just spent it. It's significant that this is happening in 2011. There was testimony that the parties had used Frontline and JZM to fund their personal expenses, and they signed joint tax returns. Both of them signed it, both of them were involved, okay. But that being said, there is no evidence of Cynthia Palazzo taking $38,000 from JZM, even though it's titled in her name. There is no evidence what happened to that money in anything resembling a marital fashion. We would ask that the court divide the $31,567 between the parties. Just to note, Mr. Palazzo's income in 2009 and 2010 hovered around $40,000 from Frontline, just as the wife's did. In 2011, on the advice of their tax attorney, he finally took in excess of $100,000. So it's really an extraordinary year for him to also need $30,000 from JZM. Excuse me. The court also missed some significant financial misconduct by Mr. Palazzo, where he appropriated joint assets, including the $40,000 officer loan, which isn't dealt with, but he specifically depleted the officer loan by $195,000 in about 3 months, immediately prior to the wife filing for divorce. He did this by buying 3 529 accounts, which are accounts used to fund tuition, college tuition. But he did this for 3 adult children. This court has seen a very similar case to this in Smith versus Smith, where this court determined that you cannot favor adult children to the marital estate by taking money out of the marital estate. In Smith, the trial court and this court determined that the money which had been taken by the husband to pay student loans for the adult children, which were taken during the marriage and could have been a joint debt, and he also paid the last year of college for the second youngest child. This court put that money back into the marital estate, and we would ask that this court return that $195,000 to the marital estate. In fact, at the time of trial, there was evidence that there had been some expenditures from the 529 accounts for the middle child and the youngest, not for the one who had graduated. So that there was a balance of $116,000 as of the time of trial. The middle child had then graduated. The youngest was attending school. He was taking one class and working full-time for Frontline. The husband testified that it was his intent to pool the 529 accounts, which you are allowed to do, and give that all to the youngest child. He actually expressed his intent to remove that money from the marital estate and gift it to an adult child, regardless of whether the child finished college or not. We would ask that this court recognize his conduct in removing, in essence, $195,000, but certainly $116,000, and giving it to the party's adult children. At the same time, the court failed to divide a loss carry forward. That's a tax deduction which the parties had jointly and which should have been allocated equally between the parties. There's no basis for doing it in any other way. There was also significant evidence that the husband spent about $59,000 to redo his girlfriend's house in California. And lest there be any doubt about this being a legitimate business expense, you have to look at the testimony concerning how he booked those expenses. He booked her hardboard floors as floor treatment. He didn't say, I'm purchasing or contributing to another office. Even then, he misstates what he's doing with the money. This is in keeping with his practice throughout. When at the temporary orders, he agreed to pay $15,000 towards the wife's attorney's fees. He took $15,000 from Frontline immediately. He booked it as professional fees, but he used it to pay for the son's wedding. And again, this is a year when he's taking real income from Frontline, not $40,000. At the same time, he purchased cabinets for $88,769, and Frontline paid him for that. But then he returned the cabinets, but of course he didn't refund that money to Frontline. We would ask that that $8,769 be divided. Similarly, he took $9,000 from the party's joint fidelity account, excuse me, which should also be divided between the parties. Excuse me. The court considered the party's property when it made an award. It granted Frontline and JZM to husband. JZM had a sufficient mortgage that there was no great value there, although the wife is still liable on some of the loans of the company. However, it granted him Frontline with a value of $730,000 and ordered him only to pay $3,000 a month with no interest and no security on this business. This leaves husband with the opportunity to sell his business, net $730,000 or perhaps more. Then he can put that money in an account and he can live off the interest of that, but he only has to pay Ms. Palazzo $3,000 per month. Without an encumbrance, that money could disappear and she could get a judgment against him, and perhaps then the court would grant interest to her against him, excuse me. But There's nothing to incentivize Mr. Palazzo to do the right thing and pay these payments with interest, or to otherwise pay her a lump sum. He has the assets which could be mortgaged, they could be used as security, they could be liquidated, and the wife still has at best $3,000 per month over 10 years.
And you're just now reaching your 5 minutes of rebuttal time. You may continue as you...
I'll be very brief then. I'm using my own time. Finally, the court used the property division payments as income to the wife. We're not talking about her getting $360,000 and then having the interest from that imputed to her. The actual payments are used as her income when the court did the spousal support in this matter. That is inappropriate double dipping, and we would ask that the court use the wife's proposed FIN plan spousal support in its order. Thank you.
Good morning, Your Honors. My name is Richard Rabb. I represent the appellee, John Palazzo. First, I'd like to address something that the appellant has suggested throughout her argument and throughout her brief, which is Appellate Rule 12B, and suggesting that that would be an extraordinary remedy. We cited to the appropriate cases on page 8 of our brief regarding Appellate Rule 12. Using Appellate Rule 12, we would suggest that the trial court will ignore the law of the case. Further, that it is an extraordinary relief when there have been repeated remands and the trial court has ignored those remands. So we would ask that that rule has no application as it relates to the trial court here. As it relates to the first issue raised by counsel, the loan to officer was considered by the judge. The judge specifically addressed this identical issue in his decision. He said that it drove the value of the company, and so it was included in the company. So that you'll find specifically in his findings.
Did it make the value of the company less or more?
The reduction of the loan to officer made the value of the company larger. And that, in fact, is a finding of the judge, which, you know, the claim to, I want the depletion of the officer loan on one hand, and I also want the larger value for the company. I would suggest, as counsel used the double dip suggestion, the judge specifically addressed this identical issue, and he said, answered that question, and he said, by example, the reduction increased the value of the company.
So if the value of the company hypothetically was $750,000 and the value of the loan was $50,000, you're telling me that the value of the business now went up to $800,000, or did it stay $750,000 or go down to $700,000?
I don't know the answer to your question specifically.
Was the value of the business reduced because of the loan to officer?
No. It was no. Okay. I'm sorry, when I was answering your question, I was referring to as counsel has suggested, the loan to officer was $150,000, let's say, and now it was only $50,000. That reduction, that going from 150 to 50, that raised the value of the company.
Okay, but what I'm asking you is now, once that money's gone,
correct.
Now there's, say hypothetically, there's $40,000 in loan to officers left.
Right.
So when they're figuring the value of the business now, which was $730,000, as I understand it.
That's correct.
Would there have been no loan made at $770,000?
No, it was considered, I understand the question now, it was considered in the value. I don't know whether it was a dollar for dollar effect. I don't know the
What's the debt that the business owes?
Indeed, and it was adjusted in their reports, both Mr. Silla and Mr. Bone. That's correct.
Okay.
So that is the first issue. Many of the other issues that are raised talk about financial misconduct, and again, I love page 8 of my report, my brief, but there we define financial misconduct, and I think part of that is overlooked. by the appellee in their argument. It talks about a dissipation, a destruction, a concealment, non-disclosure, fraudulent dissipation of assets. And there's further a manifest weight standard of review that needs to be applied there. And the facts that drove the court's decision, and this again noted throughout Judge Quinn's decision, were that Ms. Palazzo herself was in the company from 07 to 11. And even when the divorce was pending, she was there. And part of the exhibits, which were noted throughout my brief, were all the American Express bills and all of the canceled checks that are signed by Ms. Palazzo and the American Express that was used by Ms. Palazzo, all that ran through the company. The financial misconduct that she alleges, beyond this officer loan allegation, is that somehow that's simply related to John Palazzo and not to Cynthia Palazzo. And what Judge Quinn said was he ruled, he spoke on the record about credibility. He said that these folks were equally credible. He spoke about this specific issue, and he said that they both used this for their family and for their personal needs, and that, excuse me, and it was Ms. Palazzo as much as Mr. Palazzo. So they further talk about Mr. Palazzo's income in their argument, and I would again refer back to Judge Quinn's decision. Mr. Palazzo, in his final remarks, wanted an income significantly less than Judge Quinn used, over $50,000 less than Judge Quinn used. And further that, Judge Quinn used a number that was larger than the appellant actually asked for. And so the income that was used here was based upon the experts, because not only did the experts opine upon the value of the company, they opined upon what his income should have been, in particular because of add-backs for personal things that would have run through the company. So Judge Quinn took the average of the last 3 years from one of the experts. He used, I believe, $185,000, and from there he issued his decision. The loss carry forward in anything economic, what I would say there is that there is nothing in the record about this loss carry forward. I think they had one account. I think it had a $3,000 loss carry forward as a result of a transaction in that account, but that's all I know. And again, as it relates to this flooring and cabinets and discussions about those issues, that too was directly addressed by Judge Quinn. He was very contentious at the trial level and again, of course, here. So what Judge Quinn said about that was that Mr. Palazzo has to go to California not less than once a month. And the experts testified what the cost of those trips would be. And Mr. Palazzo's testimony, along with the experts, was that the cost that he was incurring out in California, essentially fitting a condominium so that he could use it as his home base in California, was far less than it would have been had he had to pay to stay in a hotel every time, rent a car every time, food and cabinets and storage and things of that nature that he needed for his largest client, who is in California. Finally, Your Honor, I would point out that the standard of review for all of the other claims that are here, other than the financial misconduct, which does have a manifest weight standard, is abuse of discretion. And I think that as it relates to the spousal support and to the property division, Judge Quinn made extensive findings about all of them. He talked about why he did what he did throughout his findings, and we think that the court should uphold and sustain Judge Quinn's ruling. Thank you.
Excuse me. As to your questions about the business value, what's significant here is when you look at a business value and there's a debt owed, it does reduce the value of the business. but the debt is owed to John Palazzo. He gets $40,000. He should have to share that with Cynthia Palazzo. Similarly, in the 4 months immediately before he said, I'm going to cut your pay and take you off the health insurance, so she filed for divorce, he took $195,000. These parties didn't have any other big cash assets. They only had this one thing that they could draw on. And he took that money, and as in Smith, instead of having it be where he could share it with his wife, he gave it to adult children. And he said, even if the youngest did not go to college, he should get that money, not the wife. Giving him credit for every payment that was used for college, that's $116,000. That should be divided between the parties. And there is evidence on all of this, and it's contained in the brief. The transcript pages are all carefully cited, so that if you hear about it in this argument, it's in the brief, including the $8,000 for the cabinets and the money being paid to John Palazzo, and then his credit card statement showing he returns the asset. But he doesn't put the money back in Frontline, where another $4,000 could have been considered in value. It's direct money that he took, he deprived her of, along with the 529 accounts, along with the $60,000 for his girlfriend's house, and along with the other depletions of assets. But that leaves us with the final issue, which is the spousal support. What property division she does get, in dribs and drabs, with no security, with no interest, should not be used as consideration when the court does its fin plan analysis. If you look at the court's fin plan, it's totally skewed by inclusion of $36,000 a year as income. This is not income from an asset she gets. If she got $360,000, it would be perfectly appropriate to include the income that could generate. The problem is that this is double dipping in an adverse way from when you have someone getting their business and then also paying spousal support based on that value. The loss carry forward there is evidence of. It's a joint asset. It reduces your tax bill. It should be divided equally between the parties. And the reason we would ask this court to do it is this is the exact trial court that decided Smith versus Smith, where someone took money just before filing for divorce and gave it to adult children for college. This is a case where the court twice asked Mr. Palazzo, what did you do with $30,000? And then his statement in the decree is there was no evidence of this. These are the kind of issues that make it important for this court to issue an order and which show that there is a manifest weight issue here. So far from being no evidence, twice the court interjected during testimony to say, I want to know about this. This is the kind of situation that should be corrected. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.
Thank you, Your Honor.
Thank you.